Hello, everybody. So we're now at module 3. Can you believe it? Only a couple more weeks to go because the summer sessions fly by. All right. So this week, we're studying how the process of a case. Bob gets arrested. What happens to Bob? How does he go through the system? We'll look at plea bargains. And then third, we'll look at the grand jury system. Okay. So a lot of fun things to unpack. So the last lecture in week 2, module 2, I ended with distinguishing between a felony and a misdemeanor. A felony is punishable by more than 1 year and or death, whereas a misdemeanor is less than 1 year. You're never going to be sentenced to death and or maybe a fine. Okay, so we're looking specifically though of a felony case for the purposes of this week. So how does a case move through the system? That's the $1 million question that should be in your head as we go through the material this week. But first and foremost, you have to ask, and it's not grand, it's grand. I forgot the D, sorry about that. But first you have to determine whether or not it's a grand jury state. Now, remember when I told you that fascinating story of how the founding fathers created the original Constitution and then 3 years later they incorporated the Bill of Rights? Well, those Bill of Rights didn't automatically apply to the states. Remember, who did the people largely mistrust? The founding fathers, the federal government. They were horrified that the federal government was just a ruse that was going to become basically another monarchy, that we really just had another King George type of situation, right? And so the Bill of Rights only pertained to the federal government. They did not apply to state action, only federal action. So it wasn't until the Fifth Amendment, and it says at the end, if you'll read it toward the end, it says, nor shall one be deprived of life, liberty, or property without due process of law. It doesn't say state, right? It's indicating the federal government, because again, amendments 1 through 10 only apply to the federal government. So pause. What the heck is due process? Do y'all know? Do you? You hear it all the time, right? You hear it in movies, television shows, you see it in case law, you see it in things that you read. But if I were to ask you right now, hey, what is due process? What would you say? Okay, I'm going to save you about $40,000 worth of law school expenses just for the first year. And that's due process is 2 things: notice and an opportunity to be heard. That'd be an amazing exam question, right? Due process is notice and an opportunity to be heard, meaning if the government wants to take away your life, your liberty, or your property, they must tell you why, give you notice, and give you a chance to defend yourself. In other words, a trial, right? They can't just take away your stuff for the hell of it. They have to tell you why and give you a chance to fight it, right? That's due process. So it wasn't until the 14th Amendment came to life that we started to see what's called selective incorporation. Selective incorporation. So you see in the 14th Amendment, it adds a very important word. It says, nor shall any state deprive any person of life, liberty, or property without due process of law. So the 14th Amendment serves as the leash. You see that GIF I have right here, the dog being drugged? Well, why was the 14th Amendment put in place? Well, because of the Civil War. After the Civil War, the Emancipation Proclamation came to effect, no more slavery, and the South, spoiler alert, lost, and they weren't happy campers. And so a lot of the Southern states said, hell no, we won't go. And so the 14th Amendment was put in place in order to, as a leash the states and bring them into compliance, right? So, but it's important to note, amendments 1 through 10 did not automatically become applied to the states. They were applied on a case-by-case basis, meaning when the Supreme Court heard a case that dealt with a First Amendment issue, then they'd use the 14th Amendment and they plotted on that amendment that is at issue. So put another way, because I know it's hard to conceptualize, guys. Let's say the state of Texas says nobody can say the word pink. And if they say the word pink, they're going to go to prison. It's a felony, right? That, until it was heard by the Supreme Court says, well, no, Texas can't do that. So we're going to use the 14th Amendment that a state cannot deprive a person of life, liberty, or property without due process of law, and apply it to the First Amendment on Texas, meaning now Texas has to respect and is guided by First Amendment protections. And they had to do that with every single amendment. However, not every amendment right was selectively incorporated. Specifically, the right to a grand jury. That is one of the few rights within the Bill of Rights and which has not been selectively incorporated, meaning some states have them, some states don't. Pop quiz, does Texas? The answer is yes, of course we do. We have a grand jury system that has been adopted by Texas, but do we have to have one? No. All right, so with that in mind, you should be asking, well, what the heck is a grand jury? We hear about it, but what exactly is it? It's not like a jury, like a trial jury. So grand juries are United States citizens that are empowered by the federal or state law to do a few things, including conduct legal proceedings. Now, this is important to note. Grand juries are hearing a case before it goes to trial. So this is before the trial even occurs. They're determining whether it should go to trial. So nobody's guilty yet. Nobody's been deemed even a defendant yet. It's just all suspicion at this point. It's all basically like, we think there may be an issue. Let's evaluate the facts to determine if Bob should be a defendant or whether Bob's free to go, right? So they conduct legal proceedings. And what they're doing during those legal proceedings is they're investigators. They are investigating potential criminal conduct. So they're allowed to require you, me, anybody. They can subpoena anybody. They have a vast amount of power. They can subpoena anybody to come and talk to them. They can ask those people to bring documents with them. They can ask them questions. They can request the prosecutor to take them to the crime scene. They can request a vast amount of options, right? And they ultimately determine whether or not probable cause exists that should make Bob, not just Bob, but become Bob the defendant who is now facing a criminal trial, okay? So probable cause is facts or circumstances that a crime has been or is occurring. There's a certainty to it, right? There's a beautiful certainty that says that something did happen. Not maybe, not might, but is or did. Right? So they determine if that is or did exist in order to push the defendant onto a trial. So the United States is actually one of only 2 jurisdictions, along with Liberia, that continues to use the grand jury to screen criminal indictments. Pretty interesting, right? Now, what states, let me move my head, require grand juries? Well, California, Florida, Georgia, Kentucky, Virginia, New York, Minnesota, Louisiana, and of course, Texas. So quite a few, right? Now, the grand jury room, again, their ultimate job is to determine if probable cause exists, and they issue what's called a true bill. Now, a true bill is just a fancy word for we think there's probable cause. That's the indictment. Okay, so you've heard a lot about that in the news within the past few years. There's been quite a few people who have been indicted by a grand jury. And that means that they have found that there's probable cause that person, there's more likely than not that person did engage in a crime or crimes. And then they should have those issues tried in a court of law. So they issue a true bill, again, an indictment. They are, now listen to my words here, 100% secret. It is not transparent. It is not transcribed. It is not recorded. It is not open to the public. It is door closed. Get the hell out. You're not in this room. Why do you think that is? Why do we not let the public into a grand jury room? Why do we not have video? Why do we not have audio? Why do we not have a transcript? Well, the answer is that person that's under suspicion, they're not guilty of a crime yet. They're not even a defendant. So grand juries are intended to be a secret so that in the event that the person has been found to more likely than not have engaged in the alleged activities at issue, then it doesn't destroy their reputation, right? Because the grand jury determines whether they did or did not engage in a crime or crimes to push them into a trial. If they decide that they didn't, then good grief, can you imagine all the information that comes out behind those closed doors? That person behind that closed doors may admit to having an affair, may admit to something else that they did at work that's maybe questionable, but not the crime at issue. So if they allow the public into those doors, they may be treated as guilty despite the fact that under the eyes of the law, they have been deemed not guilty or not enough evidence to push them into a trial. Make sense? There's also, now listen to this, there's no judge in the grand jury room and no defense attorney. Why? Well, they're not a defendant yet, so they don't have that Sixth Amendment right to an attorney yet. So there's also no judge. The only people in that grand jury room are the grand jurors, the prosecutor, meaning the DA, and the person or persons that are under investigation. That's it. So pretty intimidating, I'd say. Now, again, they have a vast amount of power and authority to investigate crime. They can demand to actually see the crime scene. They can subpoena anyone they want. So what if that happens if a state does not implement a grand jury? If that is the case, they have what's called a preliminary hearing. Okay. So remember, not every state has a grand jury system. Some states have not selectively incorporated that Bill of Rights. So they have what's called a preliminary hearing. So let's look at what that process looks like. And again, this is in states that do not have a grand jury. The offense is committed. So Bob commits murder. The police arrive on the scene. They prepare a report. And this involves talking to witnesses, taking victim statements, collecting evidence. And that report is ultimately sent to the prosecutor, the district attorney, for instance. And that district attorney or that prosecutor determines whether or not there's a probable cause to charge or not charge the person at issue. Now, used to, when you would ask people, let's say 20 years ago, who's the most powerful person in the courtroom? Who do you think most people would say? They'd say, oh, judge, the judge, hands down. Wrong. The most powerful person in that courtroom is hands down the prosecutor, because they have a massive amount of discretion in determining whether to even bring charges, whether to investigate, whether to grant immunity, whether to grant a plea bargain, and if so, the type of plea which ultimately be acceptable. Now, let me pause for a second. Think about what that means. That means if I was a prosecutor, I could say, you know what? I don't want to bring charges against that guy. That guy's a good guy. The end. And to question the decision-making of a prosecutor is nearly impossible, meaning it is extremely difficult to turn over a prosecutorial decision to charge or not to charge, to plea bargain, to not plea bargain, or to lower charges, to investigate. It is nearly impossible to open that door to determine whether or not maybe prejudice was involved, bias was involved. It's very difficult to do so. Now, in terms of a plea bargain, this is when a prosecutor offers a defendant the ability to plead guilty in exchange for a reduced sentence. Okay. 90 to 95% of cases end in a plea bargain. That is a massive amount. Now, I hope at this point you're saying to yourself, wow, that's a lot, right? And it is a lot. And it's become kind of a problem because over 87% of defendants cannot afford a private attorney. So what happens? They get a public defender. Now, a public defender has a heart of gold. Most public defenders are not in it for the money because they barely get paid anything, right? Meaning as a professor, I probably make substantially more than a public defender, which is very sad because they have the ability to be the voice of the voiceless, to prevent judicial improper judicial decisions, to protect those who may be improperly charged. So it's disturbing. So again, 87% can't afford an attorney. And so what happens, especially in larger cities, is these public defenders become slammed with the number of clients that they have. They're simply overwhelmed. So in places like New Orleans, there was a study done in 2010 in which they found that public defenders literally spent less than 3 minutes per client. I'm going to say that again, spent less than 3 minutes per client. And I saw this firsthand in New Orleans. When I practiced there, you'd go into the courtroom and they had what's called a cattle call. And this is when a lot of people who got picked up over the weekend would come to the courtroom and their public defender would show up. And it would be the first time that that public defender had even met them. They'd say, what is your name? They'd read it. They'd look over the file within 2 minutes and say, okay, I'll ask for a deal. So they don't have time to investigate. They don't have the resources to test DNA or to obtain expert witnesses. That money is just not there. And so they do the next best thing, which is they try to get that person the lowest amount of time or the lowest fine possible in light of the circumstances. And that's a theme in most large cities, including San Antonio, Houston, Dallas, New Orleans, Shreveport, Baton Rouge. List goes on and on. It's the same story, different town. So again, there's only 2 restrictions and prosecutors' actions. The first one is called selective prosecution. And this is when you have to be able to show that others that were in the same situation were not prosecuted, and the defendant's prosecution was deliberately based upon something like race, ethnicity, religion, sexual orientation, something of that nature, right? So I'll give you an example. If I'm walking across the street. No, let me rephrase that. I'm going to back it up. Rewind. If I'm driving drunk and I'm driving 50 and a 35 and I have inebriation proven through a breathalyzer at a certain rate, and I'm not even taken to jail, they just say, you know what, go home. Bad. Go home. But somebody who has the exact same breathalyzer results is driving 50 and a 35 just like me, and let's say they're African American and they are arrested and prosecuted for DUI, then that may be indicative of selective prosecution, which is a no-no. But proving that is extremely hard, okay? I put the case of Yick Wo versus Hopkins down there because that's the case that opened the door to what's called selective prosecution. In Yick Wo, you had a massive amount of Chinese immigrants who moved into the West Coast, specifically California. And this was during the period in time in which the railroad was being built throughout our country. And Chinese laborers are largely responsible for our railroad infrastructure. They built it. Well, when the infrastructure was done, the federal government tried to pull back the amount of Chinese immigrants that were coming into the country. And a lot of individuals in the United States were not happy when Chinese immigrants started opening up businesses and were successful in their businesses, especially in San Francisco. There was a line of Chinese immigrants who opened up laundromats, and they were rocking it. They were doing great. Well, the city decided to implement a tax, and it was aimed at wooden business structures, and they had to demonstrate that they took certain precautions to prevent a fire. Because if you don't know, San Francisco burned to the ground because of a fire in the early 20th century, right? So they're trying to prevent that. But the only people that they were going after with this tax were the Chinese immigrants. They weren't going after the white business owners who literally had the same circumstances. So that reached all the way to the Supreme Court, and the Supreme Court said, look, you can't selectively punish people who did the same thing, right? Based on their ethnicity, their race, so on and so forth. So again, that's a limit on prosecutorial power, but proving it is extremely hard. The only other limit on them is what's called vindictive prosecution. And this is when basically, and you can read the PowerPoint, I'm not going to read it to you, but it would be an example of a prosecutor saying, look, you either admit that you robbed this Circle K on this certain date, or if you don't, I'm going to charge you with murder, even though it didn't even occur. So you're blackmailing the person, right? That's a no-no. That's vindictive. And that, again, is a no-no. All right. So the prosecutor ultimately determines whether or not to bring charges, not bring charges. And if they decide that probable cause is present, they'll institute what's called a complaint. They'll make a complaint. Now, that complaint, and I have an example in our module, look it over. That complaint has an affidavit with it. And usually the affidavit is made by a detective, and the detective is swearing up, down, and sideways that everything that he or she is saying is true. And it will be facts and information that support their belief, their allegation that this person committed this crime or these crimes, right? So a complaint is where they submit the facts and information that the person committed the crime or crimes. Once that's submitted, once that's filed, that complaint is filed with the court, Okay. A warrant is issued. Now, a warrant is a way to get that defendant into court. So that person will be arrested. Now, in the complaint, and let me minimize my head here. When you look at it, you'll see that there's an oath or affirmation where the detective typically will swear that everything they're saying is true. They'll state the facts and information that support the offense or offenses being charged. So if they're charging that somebody committed robbery, they're going to state that that person entered this domicile or this business without the person's consent and took X, Y, and Z. Now, the affidavit is usually a part of it. It's going to be rare for a complaint not to have an affidavit. Usually it is a part of it, although technically it's not required. And again, all it's showing is that there's probable cause to bring this person into court, that the defendant committed the crime. And then the summons or arrest warrant makes sure that person's booty is in court, that they show up. Okay. Now, once they've been arrested, they have 48 hours to make their initial appearance. So that's when they come to the courtroom and a judge reads them their charges that are made against them and tells them that they have a right to an attorney. And basically, this is setting the stage. This is setting the stage for we think you did this. And now at this point, you have these rights. So this is the point where they reaffirm all those beautiful rights that they're in the Bill of Rights, right? Now, during that initial appearance, they'll verify the person's name. Now, I kind of giggle when I say this because you might be saying, well, duh, right? But you will hopefully be surprised that sometimes people get lost in the system. After Hurricane Katrina in New Orleans, they didn't have a lot of their inmates in the computer system. They were on paper, like hardback paper. And so when the flood flooded out New Orleans, they actually lost inmates, meaning they didn't know who the hell the person was or why they were there. Yikes, right? So part of this is just to make sure they have the right person. So they'll notify them of their charges and that they can get an attorney. Their Sixth Amendment right to an attorney. What a beautiful right. And then they'll advise them, of course, anything you say or do can be held against you, the right to an attorney, so on and so forth. And all of this is to ensure they have the right person and to protect them from being left in jail. So it's kind of also a check with the court to say, hey, we have this person and we need to make sure they go through the system. Don't forget about them. And they also give them the opportunity to secure bail. And then they reaffirm all the facts, again, to demonstrate that they have probable cause. Now, I probably sound like a probable cause broken record, and I'm doing that on purpose, guys. I'm beating you over the head with probable cause because this has to be shown at every single stage. Without probable cause, you cannot hold a person. You cannot search a person. You cannot seize a person, meaning arrest them, without probable cause. So it's the court's constant affirmation that they're doing everything right. They're not doing anything wrong, right? So in terms of bail, bail is interesting. Bail is found in which amendment? Okay, so I tell you what, you email me not only who the Chief Justice is, but what amendment the bail is found in. And again, 2 full extra credit points on the quiz, okay? So the Bill of Rights gives you the ability to be released based on bail, but it's not a right. It is a privilege, meaning you're not guaranteed bail. You may not get bail. They may decide that what you did was so damn bad that they're going to keep you in there, right? So it is not a right. It is a privilege. And they determine what the bail amount is based on the perceived evil. Isn't that great? I just love that phrase. So by that, they look at the seriousness of the offense. Did you steal a Twinkie or did you kill a bunch of kittens? Your prior criminal history. Is this your first time or your 1,000th time? The likelihood that you'll show up. So for that, that's important because they'll look at, do you have a full-time job? Do you have kids? Are you in school? All those things indicate that you'll stay in that area. But if you are living in a hotel room, you have no friends, no job, no nothing, there's a high likelihood you're going to skip town. So they may make the bail amount really high or not even offer bail. So look at your employment status, whether you own or rent, the length of time that you've been in the area, whether or not you have family, all that stuff. So your discussion this week is a really great one because you get a sneak peek into the preliminary hearing process in Arizona. There in 2017, a man went to Comic-Con, one of the comic book events, and he went there with the intent to kill one of the Power Rangers, the original Power Rangers. So one thing that you're tasked with doing is watching the video describing the event, but also his initial appearance. And then you must answer a bunch of questions about what was reflected in his initial appearance. And I want to emphasize something. This is rare. Most times you do not get to see the initial appearance. So it is very cool that you're able to see this initial appearance. So I hope you enjoy watching it and take notes, but also ask yourself, why wasn't there an arrest warrant in this case? Not going to tell you. You're going to have to watch it to find out. All right. So they have their initial appearance within 48 hours of being arrested. Then they have what's called the preliminary hearing. Okay. Now, the preliminary hearing is when a magistrate judge determines whether or not there's probable cause to believe that a felony was committed. This has to happen no later than 10 days after the initial appearance. It has to happen within 10 days. And it's more adversarial because at this point, the defendant has his or her defense attorney who is hopefully litigating on behalf of their rights, right? But this may be waived by the defendant. The defendant may say, screw it, I don't want to do a preliminary hearing, just take me to trial. So it can be waived. It doesn't have to happen. Again, they have their representation at this point. And if the magistrate judge determines that the defendant did, in fact, that there's a lot of arrows, green lights, pointing to the fact that he or she did commit the crime or crimes, they'll issue or they'll do what's called bind over the defendant for trial. So remember, in grand juries, they do what? They issue a true bill. And on the other side of the aisle, where there's preliminary hearings, there's no true bill, they'll bind over. But the outcome's the exact same because that defendant, that person, is now moved into a trial phase. All right. So, again, probable cause is this anthem that you're going to see again and again and again. So after that preliminary hearing, you have the arraignment. Now, at the arraignment, this is where the defendant pleads guilty, not guilty, nolo contendere, or not guilty by reason of insanity. So guilty is usually used against the defendant in a civil suit, meaning if you plead guilty in a criminal trial, they can sue you again in civil court. It's not considered double jeopardy because there's not a danger of you going to prison or jail in a civil case. It's just a money fine, right? So if you're familiar with O.J. Simpson allegedly killed his wife and her friend, or his ex-wife and her friend. And he went to criminal court and he was found not guilty, right? But the Brown family, his ex-wife's family, sued him in civil court and he was found guilty in civil court and had to pay them a lot of money, right? So, and that's because it's not double jeopardy. You're not going to go to jail or prison after being found responsible for a civil offense or civil trial, okay? Now, if you plead nolo contendere, this is a civil shield. So if you, in a criminal case, plead nolo contendere, that means they can't go after you in a civil trial. Interesting, right? So it's kind of your shield. But this is the deal. If you plead guilty, the court doesn't just automatically accept that. They have to have sufficient information or belief that the defendant actually did commit the crime or crimes charged, and that the person knows what they're doing. If the person has the mental capacity of a 5-year-old, then the court should pause, say, pump the brakes, and really evaluate whether or not they know what they're doing when they plea such a plea, okay? And that they're mentally competent. So the arraignment is where they do that. But it's also during this time period in which a possible plea bargain can occur. Now, this allows the courts to not be flooded with cases. If every single case was heard by a judge, they would be going nonstop, back to back, day in and day out, 365 days a year, 24 hours a day. Instead, we filter all out a lot of cases through the plea bargaining process. I included this link. It's in the PowerPoint. I can't watch it here, or I can't play it for you here, unfortunately, because YouTube will nix my video for showing it. But definitely watch it, because the comedian, and pardon, he kind of has a crass sense of humor, so pardon his language, but it is a really good description of the plea bargaining process. So please watch it, because there might be an exam question based off of this video. So make sure you watch it. But in essence, its purpose is to prevent the courts from getting flooded, from drowning in the amount of cases. But what it's kind of turned into is we've shifted almost all cases down that route. Even if the person we believe is innocent, they may be facing or accepting a plea of guilty just so that they can get the hell out, and there's no other options that have been afforded to them, right? Because their public defender is overwhelmed with cases. So at that point, once they've been arraigned and they enter their plea, or they've been plea bargained, which if they've been plea bargained, this won't happen. They won't face trial, and they won't be sent. They'll just accepting a lower sentence in exchange for pleading guilty. But if they plead not guilty and they don't go the plea bargain route, then the trial house doors open. So do you see how much is on the front end before they even step a toe into the courthouse doors? There's a heck of a lot of steps, right? So what about states with a grand jury system? What is the process then? So it's almost identical. So I don't want you to panic, okay? The offense is committed, the police arrive on the scene, they prepare a report. That report is sent to the prosecutor to review, and they make a probable cause determination, whether or not they think that there are facts or circumstances that a crime did occur or is occurring. And then they send that complaint to a grand jury. The grand jury reviews it, and they hold a hearing. At that point, the person under suspicion is not a defendant. Not until or if the grand jury decides, yeah, there's enough here. There's enough here. And so they may issue what's called a true bill, an indictment. Then the person enters their plea of guilty, not guilty, or not guilty by reason of insanity within 10 days of their indictment. So you see, it's almost the exact same. It's just less steps than the preliminary hearing system. So for ease of access purposes, and for you, Merry Christmas, I created a distinction kind of table for you. So preliminary hearing is in existence to determine if probable cause exists. Same thing with a grand jury. They bind over the defendant in a preliminary hearing if they believe that the person did commit the crime, whereas a grand jury will issue a true bill, indict them. The preliminary hearing is public. Ooh, grand jury, definitely not. 100% secret. The preliminary hearing is formal. There's a judge, a state, a defense attorney, whereas in the grand jury system, there's no judge, no defense attorney. Preliminary hearing, there's no right of the judge to investigate, whereas the grand jury can investigate the crime. And the jury in a preliminary hearing, they have no subpoena power, whereas a grand jury can subpoena anyone or anything they want, period. So that's it. You're now in week 3. You're done. Have fun with the discussion. And if you have any questions, you need any help, call me, text me, send smoke signals, come visit me in my office, all of the above. And I hope you have fun with the material this week. Bye.